Good afternoon. Please be seated. We are here on cause number C 2012-6655, Beard et al. Versus Day et al. Would counsel please announce their presence?
Good afternoon, Your Honor. My name is Brad Roach, and I represent the plaintiffs.
Good afternoon, Your Honor. Daniel Jerkowitz, Karen Pryor, on behalf of Pima County Defendants.
Good afternoon. I have received a special action mandamus and injunctive relief request from plaintiffs offered by Mr. Roach. I've also received from the county an objection to this hearing and a motion to dismiss. Mr. Roach, I did not receive a reply. I know we're on a compressed time frame. Is there one out there that I should have received?
No, Your Honor, I was not able to produce a reply.
Very well. Folks, what I plan on doing is this. We have basically Mr. Roach's request, a procedural attack in the form of a motion to dismiss and objection to this hearing. Because of the time compression, I will hear argument on all issues. Mr. Roach, in addition to your request, if you so choose, you may want to address the county's motion to dismiss and basically the attack on your pleadings. And Mr. Jerkowitz, obviously you can advocate your position and also let me know what you think of Mr. Roach's position. We have plenty of time. I always hesitate saying that, but we do have plenty of time. I've set aside the rest of the afternoon, so I won't cut you off. I may jump in and ask a question or two, maybe just for my education, but feel free to address this as you may. Go ahead, Mr. Roach.
Thank you, Your Honor. And I do have 3 witnesses that I would like to call for the court's consideration in terms of the record that I believe that we need to establish to ask for the injunctive and mandamus release that we are requesting.
Okay.
First, Your Honor.
Ladies and gentlemen, while we're waiting for that, everybody make sure your phones are off. Before yesterday, one of the lawyers' phones started barking. We were scrambling for it, so everybody check and just make sure all the phones are off. You may proceed, Mr. Roach.
Thank you, Your Honor. First, Your Honor, I filed with your court's clerk today in open court an amended petition for special action with verification. It should be word for word the petition that was filed last Thursday, but it includes a verification. So be that as it may, I understand that that was one of the procedural.
Has Mr. Jerkowitz received a copy?
Yes, I gave him a copy in court today also. So, Your Honor, to outline why I think we should get relief and why I think many of the objections made by the county should be overruled, we have to go back and talk about the elections in Pima County. And I think through the evidence that you will hear in court today, I'm not sure that the county will even be able to argue otherwise. The systems used, the software systems used by Pima County to tabulate the votes are, from a security standpoint, woefully inadequate to prevent both exterior attack and vote flipping or vote fraud, or attacks from within the system or within the manufacturer for voting flipping. So in other words, and I will have witnesses come up and talk in detail about why this is so. The software itself is so susceptible to abuse. What happens, generally speaking, is, and in this particular election, they're expecting about 80% of the ballots that come in, what I call vote by mail ballots, I think in my petition, early voting ballots, ballots that are not cast by people who are personally walking into the precinct tomorrow, or November 6th, the day of the election. And then the rest of these ballots we are presuming are going to be actually voted by people walking into the precincts. Those two types of votes are separated by the election law and the things that have been established to try to make sure that people cannot flip elections. Ever since the 2000 vote, or the 2000 presidential election, when, if you remember, obviously there were a lot of concerns about voting and voting irregularities, the federal government passed a number of laws and made grants available to the states to allow them to go to a purely electronic system. And so what I mean by purely electronic system is, as an example, precinct voting. You go in, you get a ballot, you go into the little closed area, you pick who you want, you put the ballot in the machine that scans the vote as you're actually dropping it into the machine. From then on, for all intents and purposes, the paper ballot that actually has your markings is no longer relevant. The only thing that's relevant is the ones and zeros in the computer storage system in that particular device. So precinct by precinct, that happens across Pima County. At the end of the day, the poll workers are required to, they're supposed to print a tally list, which is supposed to, the computer itself can tell you X number of people voted for the Republican candidate for president, Y number of people voted for the Democratic candidate for president. On down, it shows in that particular precinct who won and who lost in the actual tally, the actual number. Then they take that memory card back to the central tabulator, which is a central computer system, where the memory cards are uploaded. And all those ones and zeros, 15 votes for this guy, 13 votes for this proposition, go into a central software system, and that software system adds them all up, combines those with the vote by mail or the early ballot votes, and then that's where we get our, eventually get our official results. The problem with the system starts off with the system itself was used in Pima County, was originally designed by a company called Diebold. You will see that the names have changed because the company has changed hands. It's Premier and I think it's Dominion now. The same system has been in use and the same software has been in use since 2006. The software itself is based on a Microsoft Access database system, which was not originally designed to do things like this, high security, and actually the Microsoft Access software says it's not designed for very large spreadsheets either. Anyway, without going into too much detail, because you're going to hear it from the witnesses, there are a number of ways that this system could be compromised that could have been built into the system by the original perpetrator, or the original programmers of the system, could have been built into the system physically. People, the most difficult one, but people from outside the system could in certain ways, or by certain ways, actually get in and flip votes, and then people who work within the election department could, with certain methods that you will hear about, flip these votes. What we are asking for is a method that I believe all people who have studied election integrity, ways to verify, because there are almost innumerable ways to cheat the system. And we probably will not touch on all of them or even close to all of them. But the request that we are making to the court is one of the most, if not the most effective way to make sure that no one has cheated, or at least detect if cheating occurs. That is, at some point, the computer will spit out certain numbers by precinct for every person on the ballot and every proposition. It says, in this precinct, this is how many people voted for this person, this person, this person. If we don't know, if somebody is going in and somehow hacking the system or somehow attempting to fraudulently change votes from what was actually voted to their preferred outcome, they're going to have to do it at some point by changing those numbers. And you can do it very subtly in a bunch of different ways, but the numbers itself will have to change at some point. So if you print out by precinct each one of the results that the computer says and then the computer adds up the totals, and these are the winners, these are the losers. Then it's committed. Whoever is, if you're presuming somebody's attempting to flip the election, they're committed. Then you go back and you randomly pick precincts. In the case of the precinct vote, the votes that occur on the day of the election, Pima County historically has picked 4% of the precincts by randomly and then hand audited them. So you literally go through, and all those pieces of paper that I said became meaningless with the paper ballots that people actually use to vote in the elections. They go and get that box full of the actual paper ballots, they pop it open, and then volunteers count each one of those ballots to make sure that the numbers on paper actually match the numbers that are in the computer. That's done pursuant to state law. State law requires 2% of those to be counted. Pima County does 4%. The mail-in ballots, which again, at this point in the election, or in our society, is going to be the vast majority of the ballots, that is not done. What Pima County has done historically is, at some point during the run, so rather than when you vote in person, you personally go and put your ballot in the machine that reads it. The vote by mail ballots come into a central area, they're verified, other things occurred, and then they are stacked and put through machines that do the same thing. Scan them and then detect who was voted and put those ones and zeros into a computer. They are currently not separated by precinct. So it's just going to be, one estimate that has been tossed around is about 300,000 early ballots are going to be just in one area that are not going to be, or at least Pima County has indicated that they're not going to separate them by precinct. The county then just randomly says, all right, we're going to stop the machines and we're going to create a sample batch. So, and you'll hear the details of how they do that. They print, they stop all the machines, make sure nothing is being scanned, and then they say, all right, we're going to create a sample batch of usually 125 votes. And then they will print a summary report of the vote totals for all the votes at the beginning of that batch and a summary vote at the end, and they take those ballots and put them separately. All the other votes are usually done in batches of about 500. Then, when the race is over, the state law currently requires a minimum of 1% of the vote by mail ballots to come in, or to be hand counted, but they are not randomly selected, like the precinct ballots for the votes that are done that day, because those are picked randomly after the computer's already told that you have to disclose these numbers. These are not randomly, they have been already picked while the county's in progress. And there are ways that if you were a person who was intent on flipping the election, you could therefore avoid any changes in those small batches to make sure that you could still flip the election and nothing would be detected. So what we are asking, the injunctive relief that we're asking, and we're asking the court to do this through its authority, its equitable authority, is going to be to order Pima County to sort the vote by mail ballots by precinct. And at the end of the case, I'm going to offer a number of solutions to that to try to minimize the difficulty in doing so. Sort them by precinct, and then, and I think the most effective way to do it would be to, since the county's already going to be randomly picking 4% of the precincts to be counted or to be audited from the vote in the precincts, use those same precincts and hand count those ones from the vote by mail. So that therefore, this is going to be by far the best method to make sure that nobody has been able to successfully access our system and take away each fundamental plaintiff's right to vote and plaintiff's right to know that the vote as it comes out of Pima County reflects all their desires of the fellow members of voting public here in Pima County, rather than some nefarious either employee or outside actor who has changed the ballots. One of the good parts, the way I look at it in litigating this particular request, is I'm going to present some evidence to you of concerns that we've had, that voting members of the community and plaintiffs have had about past elections. it is not necessary, nor am I going to assert to you that I will prove that any past elections have been tampered with. The only reason we will present that evidence is so that the court understands why people in this plaintiff's group have decided that this is the only way that they can make sure that their votes and the votes of the other members of Pima County voting public are the ones that are actually reported. So that's the injunctive relief that I believe the court has equitable jurisdiction to enforce. The mandamus relief is a much more specific act that we're requesting. At the precinct level, as I said, at the end of the day, they go and they print out what's called the summary report in the Pima County election manual for the poll workers. They call it the AccuView election results report. They print one of those out, and again, that's the one that says the actual number of votes for each individual person and each individual proposition at the precinct. Right now, Pima County, through their elections handbook, requires that the poll workers put a copy of that in the unofficial returns envelope. But they do not follow the required state law that says you must put a tally list into the official returns envelope, which makes sense for a number of reasons. It's the official returns envelope. That's an envelope that is a much more secure envelope that is held solely for the purposes of objections or Board of Supervisors overview of the election. And our position is that ARS 16615 requires that to be done. And so for that reason, mandamus relief is appropriate in that particular instance that we're going to ask the court to order Pima County to send, basically what we're going to ask is them to send a notice to each one of the 218 or 280 some odd precincts on the day of the election saying, no, please add one of these AccuVote elections results report to the official returns envelope. That's kind of an overview of what I'm planning. I have 3 witnesses that I would like to call. I have Mickey Donahoe, who is present. He's a plaintiff. He is a long history working with security and security within organizations. He has worked on and is part of the Pima County Elections Integrity Commission, which is a public commission that was appointed by the Board of Supervisors to help them in terms of making recommendations for making sure that the Pima County elections have integrity, that they are not messed with. He's going to testify about how these votes can be split, the physical things that are done and the things that are done currently to try to make sure that nobody is able to tamper with the elections, and why those are inadequate so far. We are going to have Ted Downing testify. He will be rather short. Ted Downing was a member of the State House of Representatives that authored the bill that allowed hand count audits to occur in the first place, or that mandated that they do. What he will talk about specifically is that while he was drafting the bill, he was told by Brad Nelson, who is the head of Pima County Elections Department, that if he included county races, and I omitted that, we may hand count precincts at 4%. We may do, to some extent, hand count early ballots. Right now, Pima County does not count at all. There's no audit in any way of the county races for the Board of Supervisors, the county recorder, other things like that. That is because Brad Nelson actively took a role in making sure that that was not part of the state law. He told Ted Downing, if you put that in the bill, we will kill the bill, meaning myself along with the elections director of Maricopa County. So that's why we now have a system where the county does not have to audit its own race. I think that's important when the court is making its final equitable decision. And then you're also going to hear from plaintiff Jim March, who's going to talk about, again, further attacks that could be made on the system itself, and give you some history of some of the concerns that people have had about elections as they've been tabulated here in Pima County in the past. So after all that, Your Honor, we're going to ask that you order relief as requested.
Before you go, Mr. Jerkowitz, and Mr. Roach and Mr. Jerkowitz, even said, maybe I didn't make it clear when we started. I am going to hear the substantive argument, and I'm going on substantive evidence. I'm doing that more out of a judicial economy approach. I don't want the fact that we are going to hear testimony today to be interpreted as some sort of indicator to either side that I've already made up my mind about the procedural issues. So, Mr. Jerkowitz, I don't know if that was something that was weighing on you, and Mr. Roach, I don't know if it's you either, but we have all these folks here. Obviously, this is an issue that has a lot of public concern, and it's great to see. So we're going to do the whole thing today. But just so it's very clear, I haven't made up my mind about the procedural aspects of it, and I will afford you an opportunity. Basically, we're going to have an evidentiary here, and I will basically allow you closing arguments, for lack of a better term. And I will allow you to address what I expect to hear from Mr. Jerkowitz being a procedural approach to this, and why I shouldn't be having this hearing at all. So,
yes, I understand.
and I will, but just so you know, Mr. Jerkowitz, Mr. Roach, I will afford you the opportunity to respond. Go ahead, Mr. Jerkowitz.
Your Honor, for the record, despite what the court's just stated, we do object to the production of evidence today. When the court set this hearing, it did not say it was having an evidentiary hearing on merits. Pima County is not prepared to go forward on that basis. Additionally, I don't believe any of that's going to be relevant to the proceedings. And thirdly, I think it's kind of moot at this point. Pima County has already counted, from what I understand, close to 60,000 early ballots. Early ballot batches have already been pulled from them. So this process, it's way too far gone. You can't file this kind of an action right before the election and try to seek relief. The metaphor is that the cow's out of the barn, so to speak.
Let me ask you this before you're on, Mr. Jerkowitz. Are you, among other things, are you asserting that the county is being prejudiced because of the compressed time frame? You would have had perhaps your own witnesses and presented controverting testimony or evidence that might address some of the issues that would be raised by the plaintiffs?
Absolutely.
Well, let me ask you that. Well, go ahead and we'll address it at the end of this proceeding.
Okay. Go ahead. As to Mr. Roach's concerns of elections integrity, I think concerns for elections integrity are well founded. There are state laws to protect them. There are state rules to protect elections. We've had previous litigation in Pima County on this topic. And one of the things that, because of the court order, we now do is we turn over the databases of all our the central count computer to the political parties for them to go through and make a forensic analysis of to determine if any fraud has gone on. No other elections department in the country does that, to my knowledge. The county has, Board of Supervisors has created an Elections Integrity Commission that Mr. Donahoe is a part of. The purpose of that committee is to provide advice and recommendation to the Board of Supervisors on what they think should be done as far as conducting the election. The Elections Integrity Commission met last week and made a recommendation to the Board of Supervisors that the early ballots be pre-sorted by precinct. However, Your Honor, that's a policy decision for the Board of Supervisors to make. And that's certainly within their authority to accept that recommendation and proceed with elections in that fashion. But that's a discretionary action for the board, and the court doesn't have any authority to order the board to do something in a certain fashion. I also want to say that Mr. Donahoe was very candid in the papers last week. He said, quote, "My feeling is that today elections in Pima County are processed in a very good manner." And I think we've made considerable strides forward as far as protecting the integrity of our elections and with a lot of assistance from these good folks who are concerned about that. However, this particular proceeding is just inappropriate. There is no authority for the court to issue the kind of relief that plaintiffs have asked for. We would also object to plaintiff's amended complaint as a day late, $1 short. I don't believe that the verified party is beneficially interested in this proceeding, and the court would have to order this plea to be accepted, and we would object to that.
Before we move on, I'm troubled, Mr. Roach, by a comment Mr. Jerkowitz said in response to my question. We want to meet the playing field. 3 witnesses lined up, and they're going to provide me with evidence and testimony, and Mr. Jerkowitz doesn't have anybody. And really, we're in this pickle because the first we heard of this action was, at least my office received an incomplete pleading from your office on Friday, on the 26th. I don't know when Mr. Jerkowitz received it because the incomplete pleading I had did not have a distribution sheet, so I don't even know if it went to Mr. Jerkowitz. As you know, I originally dismissed this pleading because of some technical problems with the pleading. We remedied it over the weekend, and I got it back, and so I vacated that dismissal. I'm concerned about fairness here. I guess my question is, before we get started, where have you been? Mr. Jerkowitz brings up a point. I know Judge Bryson was dealing with something like this back in May, and I also know Judge Miller, Mike Miller, had been dealing with something like this back in 2007. The Diebold Gems computer program has been in use and in existence for several years. I'll be honest with you, when I got this pleading on Friday, the first thing I did is stare at it and try to think what I could do to accommodate the concerns of your claims, but also to be fair to the defendants. So maybe before we launch in, maybe I spoke a little too soon. Where have you been with this?
Judge, what I can say is I can only go when I'm approached by people who ask me to help. I was asked sometime before I filed it, probably.
Let me stop you there. I'm not going to ask you to divulge attorney-client information.
So I can only answer it this way, Your Honor. I know that the specific concerns that you had, I did not put a distribution list on the complaint because I had not, in fact, actually served anybody. I filed the complaint on Thursday night after hours, 6:30 p.m. I had the complaint served on all the defendants and the board of directors on Friday morning, and then this person who did the service of process filed, I think, what you were requesting, and then I also the proof that they were served, along with the memorandum in support thereof, was also served, or was not served, was delivered on Friday. So I understand. I mean, that's not to discount. This is still for the legal system, lightning fast.
Sure.
But one, that's not always been true. That things happening within a week have been somehow outrageously fast. It's how we do things now. I would say first, the Pima County chose to. They could have done what I did, which was I got the court's order setting today's hearing, and then I called your office and I said, "Is it set for 5 minutes, or is it how long is it set?" And it was set for 2 hours, I think, at that point. And I was told. And that's how I knew, okay, this was not, we're going to get together here and talk about, say, maybe just the jurisdiction or scheduling to schedule something for next Monday. This was how I knew that I should have my witnesses prepared. And so I think that was a choice that they made. And I would say that it had some tactical benefit to them to not come with witnesses because then they would not be prepared. What I would also offer, though, Your Honor, is I'm available and I can make myself available whenever the court wants to have a continuation hearing so that they can offer, we will offer our testimony and then they can offer rebuttal testimony. And that could happen in the future. The mandamus issue needs to be addressed before November 6th. Now, it needs to be addressed, it could easily be, I would present to the court, it could easily be, if the court ordered in our favor, rectified within 24 hours of the election. The vote, or the separating the early ballots by precinct and then hand counting them, that itself does not necessarily have to have been ordered by the court before November 6th. It does need to be ordered pretty soon thereafter, because at some point, when a canvass is released, then state law says these ballots must be locked up and no one is ever able to see them again, absent an act of God. So they would need to happen before then, but it would not necessarily have to happen exactly on on or before November 6th. And what I would suggest is, even though it is of no moment to your final decision that they've already started counting early ballots, good. Because that doesn't matter, we wouldn't even necessarily ask that they start to pre-sort them until after the election anyhow. So I don't think they've started actually tabulating changes anything. So I know this is fast, and I knew when we filed this that we were going to be asking for movement that is very quick. But that's what we're asking. And I think it's like saying, the Constitution says we have a right to be free of unreasonable searches and seizures, and because the government already has some statutes requiring the state to do X, Y, and Z with regard to search warrants, then the court doesn't have jurisdiction to enforce the constitutional requirements. And I say, no matter what time frame you are presented, any court is presented, you have the authority to order in equity that our Arizona state constitution is upheld, and in the mandamus action that they follow the state law as required by the state legislature. And so, even though it's fast and I understand that, and I'm prepared to allow the county, if they want to call other witnesses, I'm available for that, but I still think it can all be done before the election in a fair manner.
And Mr. Roach, I don't want you to think I'm picking on you. Anybody who's sat at one of those tables, including me, knows what it's like to be under the gun and working late and filing. So I'm not picking on you. Mr. Jerkowitz, here's what I'm inclined to do. We're going to hear testimony today. If the county, if you want to approach, we'll get another hearing scheduled relatively quickly. Maybe I see my judicial assistant looking at me thinking, when are we going to do this next week? Because we're pretty busy.
And unfortunately, Pima County is also kind of busy. We're trying to run an election at the moment. So
I understand.
can't really drag my elections officials out at this point in time to handle this kind of stuff. They need to be running the election. We're counting ballots already. The whole thing is going forward. So this is not an opportune time to be doing it.
What we're going to do today is I'm going to hear testimony, and like I said, I have not ruled, and I'm not telegraphing that I'm going to which way I'm ruling on any of the procedural attacks on plaintiff's motion. But because these people are here, I am going to hear testimony today, and obviously cross-examine if you so desire. Go ahead, Mr. Roach.
Thank you. The plaintiff should call Mickey